Editor-in-Chief of JCRED. It has been an absolute honor serving as Editor-in-Chief, and I'm so thankful for everyone on JCRED who has worked so hard to bring this symposium together. I'm very excited for this spring symposium on a very important issue and something that's very near and dear to my heart, as well as a lot of other people on JCRED's hearts. So I'm very excited for tonight. I want to thank everyone who has helped put the symposium together, everyone at St. John's Marketing Department, everyone on JCRED, and of course to Catherine, who has done a wonderful job putting this event together, who saw this event from its inception, thought of the call for papers, decided this was a perfect topic to write about, and especially now, given the current state of affairs in the country. So I so look forward to everything that's going on tonight, and I'm going to pass it over to Catherine to lead tonight's event. And if you see my video disappear, it's because my internet's not great, but I promise I'm here this whole time.
Thank you, Abby. Hi, everyone. My name is Catherine. I'm the Research and Symposium Director for JCRED. As Abby said, we want to thank you all for coming. I know it's a little late, but we do want to thank you for your time. We have a group of diverse scholars here that will enlighten us today with their research and give us different insights into the shortcomings of our criminal justice system. As Abby said, this is really a topic we as a journal feel very passionate about. It's something that we have been looking forward to for the past year. It's something that we started from the beginning. And yeah, let's begin. So our first author is Professor Sherman Clark. Professor Clark graduated from Harvard Law School and practiced with the law firm of Kirkland and Ellis. Before he joined Michigan Law School, he teaches courses on torts, evidence, and legal ethics. Professor Clark's research focuses on the connections between politics, law, character, and well-being, drawing on classical philosophy, modern psychology, political theory, literature, and law. He has written about institutions and practices ranging from direct democracy to the jury to criminal procedure. So the floor is yours, Professor Clark.
Thank you, Catherine, Abigail. Thank you so much for putting this together. I know there must have been times this spring where you were like, what did I get myself into trying to do a symposium? But we appreciate it. It is an important topic. And I appreciate the opportunity to put my 2 cents in. So I feel like I almost ought to apologize for the points I want to make. I'm not really, but the point I want to make may strike you as off topic or even perverse. And I hope I can convince you it's not really off topic and not perverse, but worth paying at least a little attention to. The reason I say it's off topic is that your focus, the appropriate focus of this entire field of which this symposium is a part, is on the people who are incarcerated, the millions of people who are so badly treated and disregarded by our society. That is and should be our focus, our collective focus, their rights, their interests, their concerns. And I'm going to talk more about us, the people who have been complicit in the incarceration, rather than the incarcerated. And I just want to make clear that none of that is meant to suggest that the main concern should not be on the people who are incarcerated. It should be. It should be. I'm just adding a little, what might seem like a strange wrinkle, an ironic addition to the debate. And the reason it might seem perverse is I want to suggest that locking people up in the way we do is not just bad for them, but it's bad for us. It's bad for us. And I think the reason I almost want to apologize for that is because it matters what reasons we have for doing things. Okay? So I worry that by giving in part selfish reason for caring about other human beings, that I am undercutting the real and deeper reasons. And I don't mean to do that. So I don't like it, for example, when people say that, when people argue that poor education for our young people is bad for the economy, or that liberal arts education is good because it'll help you get a job. Those things are true, but we should also care about the more fundamental values at stake. So I want to situate my position saying that I don't mean to distract attention from the underlying values. Okay, so what is the concern I have? The concern I have is that collectively, as a society, we refuse to face what we do. We got 2 million people locked up, suffering brutality, inequality, inequity, circumstances, inhumane circumstances. And sometimes that might amount to cruel and unusual punishment. Sometimes it doesn't. Nobody knows what that means. But it's terrible. Okay. And some of the other contributors here and in the field more generally are calling that to our attention. But collectively, we close our eyes to it. We put our prisons way the heck upstate, and we try not to look, or we sanitize it with false impressions, or we justify it with lame arguments. So my concern here is that we are not collectively honest with ourselves about what we are doing to our fellow human beings. And I think that that matters. It matters, first of all, because if we faced it, we might treat our fellow human beings better. I'll come back to that. That's the main thing. But also, and here's the point that's going to seem a little strange. Here's my, you want to call it a contribution, modest contribution, 2 cents, whatever. Okay? I think it's bad for us not to face what we do. It's bad for you, for me as a human being, to blind myself to what I do or what is done in my name. The things that are done on my behalf and in my name, or the things that I do, I should face them. I should acknowledge what I am doing. I should confront internally my agency in those things. And here's why. I think that in order to avoid doing that, in order to avoid the pain of not wanting to confront what we do, we do 2 things. One, we blind ourselves. We don't look. We look away. We don't face the truth of what's going on. So that's step one. We can't see it. We don't want to look at it. And this happens in a lot of areas of life where we don't want to really look at what's going on. Okay, we want to hide from it. So that's one thing we do. We blind ourselves. We not only blind ourselves to the conduct, but we blind ourselves to the humanity of the people we're doing these things to. We talk about criminals as if they're a separate subset of the human race, as if there were anyone but you and I for whom things did not go well, as if we blind ourselves to the humanity of our fellow human beings, blind ourselves, squint, close our eyes. We diminish our vision. And then after blinding ourselves, we lie to ourselves. We feed ourselves bogus justifications, half explanations that don't stand scrutiny about how you shouldn't break the law if you don't want to this, that. The things that we do, we blind ourselves and we stupefy ourselves. I'm going to say specifically 2 things that we don't want to confront, that we don't want to be honest with ourselves about, just as an example. One is the whole question of desert. Like, what does it really mean to say that someone deserves punishment? Now, look, I'm not fixing to solve this problem. This is a fundamental problem of political theory, of religion, of philosophy. It's tied up with the question of free will, for goodness sake. No one's fixing to solve the problem of who deserves what and whatnot, right? But it's there, and we should be wrestling with it, but we don't. We feed ourselves half bogus little explanations. The other thing that we don't face is complicity. What I mean by complicity is, to what extent do we bear some form of responsibility for things that were done on our behalf or that are done on our behalf, even though you directly didn't do it, right? Even though I directly didn't do it, don't we somehow share some responsibility collectively? Hey, we take collective pride in the things that our nation has accomplished and the things that we do well. We share some form of collective complicity in things that are done on our behalf, even if we didn't do them ourselves, even if we didn't direct them. This, of course, is connected not just to mass incarceration, but also to the treatment of Native Americans, to the legacy of slavery, to many horrendous things that we bear some complicit connection with. Not a direct, causal, instrumental connection. That kind of responsibility is easy to understand. You punch me in the head, I sue you. I'm a torts professor. I understand that kind of causation and responsibility. I'm talking about the more complicated ways in which our culture implicates us in horrors or difficulties. So desert and complicity are difficult problems that face us as human beings. And by hiding from what we do, by hiding from the humanity of so many of our fellow men, by blinding ourselves in that way and stupefying ourselves. In other words, I want to put it this way. In order to accept our explanations for why mass incarceration is tolerable, we have to disable our internal bullshit meters, if you excuse my French. We have to dumb ourselves down a little bit, okay? Because it's horror that we can't confront. So my thought is that in order to avoid really seeing and feeling our terrible complicity in the horrors of mass incarceration, we blind and stupefy ourselves. And then I think the next step in my point is that's bad for us, because it's hard to find your way in life if your eyes closed and your reason is disabled. If you blind and stupefy yourselves, you're going to be less able to find your way to a good and rich and happy life. So my thesis, my concern, my worry is that we as a community who should be struggling to figure out how to live together well and fully, how to thrive as individuals and communities. Well, we can't do that well, because learning how to thrive as an individual in a community requires that we see well, that we see ourselves and our conduct and each other well. It requires that we think clearly about the connection between who we are and our conduct and whether we thrive. Thriving, living well as individuals in a community, which is what I think we want to do, is hard to do if you got your eyes closed and your reason stupefied. In order to figure out how we're going to live together, what it means to live well together, rather than live in stupefied fear, if we're going to do that, we need to become a people who see honestly what's going on, see ourselves and our conduct honestly, and are willing to think about it honestly and well. And the process of blinding and stupefying ourselves that we do to protect ourselves from having to face things like mass incarceration, I think end up disabling us, crippling us in a way, making us blinder and stupider, and thus less able not only to treat prisoners well, but to live well, to figure out how to live well, to confront all the other problems we have. And so I think that it would benefit long-term all of us to more honestly confront what we're doing, even if it's really painful to confront, and even if we can't figure it out. I'm not claiming there are easy solutions to any of these problems. I'm just claiming that we should honestly confront them instead of blinding and hiding ourselves from them. So that's the gist. I want to say one more thing, just one minute more to situate that, because you might be thinking, well, that's all very strange and interesting, Professor Clark. Like, what is that? Is that even a law, or what are you even doing? Is that philosophy? What is this? What if somebody says, like, what did Clark talk about? You're like, I don't know. He was waving his hands around. I don't know what he was talking about. Okay, here's a way to describe my approach. One way to describe it. It's a form of virtue ethics, a form of classical virtue ethics. I might even say communitarian classical virtue ethics. And what I mean by that is that virtue ethics is the kind of philosophy that the ancient Greeks were doing. Socrates, Aristotle, they were trying to figure out, how do you live a rich and full life? That's the kind of philosophy they were doing. That's what I call virtue ethics. Some modern philosophers have a different idea of virtue ethics as kind of a second order deontology, but I'm way old school. Like, that's what Socrates and Aristotle were doing. And they were figuring out, how do you live well and fully as an individual and in community? What are the traits and capacities that you need to nurture if you're going to live well together or as an individual? That's old school philosophy. That's what I call virtue ethics, classical virtue ethics. And I say communitarian classical virtue ethics because I just like to make it sound longer. No, because I'm not just talking about how you or I can thrive as individuals. I'm talking about how we can thrive. So if you want to say, well, what is Clark going on and on about facing up to what we do? It fits in the framework, in my mind, of classical virtue ethics, because what we're trying to do is live well and fully together, right? And in order to do that, we need to see ourselves and each other and our conduct clearly and be able to talk about it honestly, right? And if we are blinding ourselves and stupefying ourselves, we're not going to see ourselves clearly. We're not going to be able to think well and honestly about how to thrive. And where is it? Why is it that we blind ourselves? Why is it that we stupefy ourselves? Because we're afraid to look at what we're doing. And some of the main things we're afraid to look at are the kind of injustices that we're here to talk about tonight. We have many great historical crimes, the genocide of Native Americans and slavery, to list just two. But a big candidate for our number one top current terrible thing that we're afraid to face and own up to is the cruelty of mass incarceration. So what you're doing, making us, you collectively, I mean a field of scholars that are calling attention to these issues, all of you, students, scholars, calling our attention to these issues. What you're doing, I think, is, just let me say, from my perspective, is enormously valuable, not only because it might, at the margins, help solve some of the problems, help us treat people less cruelly. I hope it does that. But also because by forcing us, encouraging us to look honestly, I think you're going to empower all of us to better grow and thrive. Or at least that's my hope. I go on and on, but let me just stop. Let me just stop.
All right, thank you. Are there any questions for Professor McGowan?
Oh my goodness.
I have a question.
You do?
Yes. When we are thinking about being blind to a lot of the injustices that people incarcerated are facing, I like to think that a lot of it is the act of institutions who are intentionally shielding human rights abuses from the public eye, who are intentionally making sure that we are blind to how bad things are. So what do you think is something that as individuals we can do to kind of combat that? Or what can we do, for people who are outside of the legal community, who aren't in jails, who aren't in prisons, who aren't visiting them? What is something we can do to kind of fight back against these institutions that are really making it difficult to see a lot of the injustices that we are seeing?
It's interesting. I think that it's not so much the active repression of the information. There is that, but I think it's equally a sort of collective unwillingness to look, because people write books and publish articles. People do TV specials about the terrible conditions. People do scholarship trying to wake us up to what's going on, right? And somehow we manage not to face it. So I agree. I don't mean to disagree with you. It's certainly true that by institutions that put prisons far away and limit access to the inside of prisons do stand as barriers to the information that people want to know. That's true. But I think more deeply, what we need to do is cultivate a collective attitude of honest willingness to confront things. So all right. I got to say one more thing. Okay. I'm not going to run on and on this time, but I want to situate my concern and end this problem in a larger issue. Democracy requires people with certain traits and capacities. Democracy does not require us all to be politicians or engineers or economists or anything like that. But I'm not sure democracy can work if we are collectively too easily bamboozled and frightened into believing silliness or ignoring real problems and panicking over fake ones, right? And I think collectively, one of the pressing problems that confronts us as a community is that we're not nurturing in ourselves the kind of capacities that democracy needs. We're too easily bamboozled and frightened into believing foolishness or panicking about stuff that we didn't need to panic and ignoring stuff we ought to worry about. So my broader concern is how can we collectively cultivate the traits and capacities that not only each of us need, but that democracy needs? Because until we do that, lots of people like you and our guests are going to be sort of crying into the wilderness to a nation that's too willing to accept some oversimplified story about tough on crime and not willing to look past that. Yeah.
Thank you. I have a question.
Yes.
So I have a quote in your article, so just kind of like a sneak peek. So you say the pain of another will be an object of my concern only if I acknowledge some sort of a community between myself and the other, understanding what it might be for me to face such pain. So do you believe that we choose to disassociate ourselves with individuals that are incarcerated, and I guess in a way find it easier to lack sympathy because if we show some type of humanity or connection with them, it'll kind of show us that we're not that different and can also end up in those situations?
100%. 100%. I think one of the essential human capacities, essential meaning most important, is empathy. That is my ability to see the world as you see it. Also, I care about sympathy, which is my ability to feel badly for you. But I mean, first, I mean empathy. That is my capacity to see things as you see them. And I think that's valuable to us as lawyers because it's the key to persuasion. It's valuable to us as leaders, but it's also painful and difficult. Remember that giant dude, speaking of prisons, remember that giant guy in the Tom Hanks movie? Okay, the movie was called, what was the movie called? Green Mile, Last Mile, something like that. And the giant dude, played by Michael Clark Duncan, here's why he suffered. Because he could take in everybody else's pain. Okay, he suffered from an excess of empathy. And there's a parable in that, which is, it hurts. It is difficult to see the humanity in our fellow man. So I think you're absolutely right, Catherine, that one of the things that we do to prevent ourselves, to immunize ourselves, is limit and refuse to see the humanity in our fellow men. We recognize that this happens in wartime when people dehumanize enemies, but it also happens among our own world when we dehumanize those we incarcerate, say criminals. And I think that that's exactly an example of what I'm talking about, Catherine. It's exactly an example. We limit our ability to empathize in order to save ourselves the pain of facing up to what we're doing to people, okay? And how that could just as easy be me, you, or my baby brother, your baby brother, anybody else could just as easy, right? We don't want to face that. So we limit our ability to empathize. And my addition is, not only is that bad for the person with whom we refuse to emphasize, that's bad for us. Because empathy is a way in which we see and learn about our world. It's the way in which we gain perspective on our world. It's the way in which we see ourselves better through the eyes of others. So empathy is a valuable tool for me in my attempt to live well, for you in your attempt to live well. So when we de-empathize ourselves, that's not even a word, but when we cripple our empathetic capacities and other related capacities, my point is we not only are we exacerbating the harm that we do to others, we're ultimately, ironically, crippling ourselves too. I mean, that's exactly the point. Thank you.
Yeah, thank you. That was very, very informative. So there will be a time at the end for further questions if anyone is interested. But thank you, Professor Clark. You provided a lot of insight, a lot of information. So next we have Professor Angela Dixon. She's an assistant professor of law at Mississippi College, where she teaches criminal procedure, health law courses, and professional responsibility and ethics. She received her law degree and undergraduate degree from Vanderbilt University and her Master of Public Health from Emory University. Her scholarly and research interests include criminal procedure, particularly the criminal justice system, health law, civil rights, ethics, law, and religion, and various intersections thereof. So Professor Dixon, you can go ahead.
Can you all hear me? Can you hear me?
Yes.
Okay, great. I'm going to share my screen.
Okay.
Can everyone see?
Thank you.
Can you see it?
Yes.
Okay, great. Okay, thank you for allowing me to be here. I'm excited to be here. And I hope you enjoy the presentation because it is an important topic. Tonight, I'm going to speak about equalizing disproportionate death and punishment in Black and Brown communities, an emergency shutdown on death, inequality, and deliberate indifference. This category of cases has to do with what we call conditions of confinement. And it's a very broad-ranging category. It can range from anything from rape of prisoners to denying prisoners toothpaste. And tonight, we're going to talk about COVID-19. And COVID-19, of course, it was called the new coronavirus because the novel coronavirus, because it was new. And a lot of the science was developing in real time. So there was a lot of disagreement. And courts had to figure out a way of basically judging these cases. So what they did was they used the CDC's interim guidelines. However, there's some criticism of that because there was potential over-reliance on that. And we'll talk a little bit about that later. With these cases, everyone knows by now the mitigation measures were very important. And the one that was especially important is social distancing. So the problem with prisons is that it's very difficult for prisoners to socially distance because they're congregate settings and people are close together. So what we had was a very high viral spread within the prison system. And anywhere where there was a prison, there was also higher spread in the surrounding community. And the reason why is because people came into the community, brought the virus in, and then it gets in and spreads like wildfire, and people are exiting the prison, going out, taking it out, bringing it back in. I always say that the blessing of the virus is also the curse. So the blessing is that the overwhelming majority of people will be asymptomatic. They'll have no symptoms or very mild symptoms. Unfortunately, for people who are susceptible, people with underlying conditions, people who are older, who have those types of issues, it could be very lethal, so very deadly. And someone who is asymptomatic could be passing it on to someone who could get it and potentially die from it. So we know that millions of people contracted it, and also over 1 million people in the US died. We led the world in that. And I just want you to monitor this, this slide that I have on death and deliberate indifference, because if you look at the top, you'll see numbers. And if you look at those numbers, you'll recognize that during the period of COVID-19, once we got to 2022, more people had died from COVID-19 in prison. So more prisoners had died than have prisoners from the modern day death penalty in its totality. Okay, so the prisoners were alleging that this is a death sentence, and this is how they were phrasing it before the court. But take it, obviously they weren't being sentenced to death before a court, but they're saying post-sentencing, we're being sentenced to death by having to remain in these congregate settings. I just want to just outline the cases, the important ones for deliberate indifference, because this is the hurdle that the prisoners had to overcome. And it's a very difficult standard. The Estelle case is the case that entitled prisoners to medical care. It introduced the standard deliberate indifference. The Sider case made a two-step analysis if you have these conditions of confinement claims. One, you have to look at the objective harm, and that is what is going to be the serious or grave injury. Here it would be COVID-19. And two, you have to determine if there is deliberate indifference. That is the culpability standard. Farmer v. Brennan is the case that fleshed out the standard because it is sort of a kind of sticky standard, and courts were all over the place with it and didn't really know how to interpret it. So basically, the court said in order to determine deliberate indifference, you need to basically have subjective recklessness, and that is basically knowing of the harm and potential harm and recklessly disregarding it. And then the Helling case is a case that dealt with secondhand smoke. And why that case is important is because it said that this standard can apply to a future harm. In other words, you don't have to already have been harmed. Just the possibility of being harmed is enough. That's important for COVID because some of the prisoners had not gotten COVID yet. So who are we talking about releasing? The experts were recommending that all prisons go down to at least 85% capacity. So we're looking at nonviolent offenders, people who are older, people with terminal conditions, possibly some people nearing the end of their time in prison. And one of the categories that was real interesting was the marijuana convictions. And more than almost 40 states have made medical marijuana legal, and several states have made recreational marijuana legal. And you have all of these people languishing in jail. And I put down here the President's Club because 5 of 6 of our living presidents have had encounters with marijuana. Either they've tried it themselves or they've had children who've had issues with marijuana. So I put them up there because it shows what a crime of inequity it is. You can have people who basically end up behind the slammer and people who end up at the top realms of power. It's just a luck of the draw, right? So the other thing about it now is that it's a multi-billion-dollar business, and it's a business where a lot of Black and brown people are languishing behind prison still. And then you have primarily white people becoming rich off of the business. In terms of incentivizing release, we had both Congress and the Attorney General doing that. Congress passed the CARES Act, and with that, they urged statutory release. They expanded it to release more prisoners. And then the Attorney General actually urged home confinement. And with home confinement, the problem that we had initially is that the people who were being released were largely white and wealthy. And Michael Cohen and Paul Manafort were 2 examples that were in the news early on. Part of it was access to counsel. People who have means have access to counsel generally. But the other part of it was that the assessment tool used to determine who gets to go actually favors white prisoners over Black and brown people in terms of how it's pre-programmed and what it's looking for. These people are deemed to be less of a risk to society. Fortunately, compassionate release was more equitable, and that's largely because of the First Step Act that was passed. Prisoners had a lot more success with that than they did with the home confinement. I want to talk just a little bit about punishment, because technically with this with these conditions of confinement cases that we have, we are supposed to be able to say that people are being punished post-sentencing. The problem is that that really hasn't become the dominant jurisprudence on punishment. The dominant jurisprudence has been that punishment is meted out by a judge or a jury. So in other words, death must be sentenced. And if death occurs after incarceration, it can be challenging sometimes depending upon how that happens, because you have to get past that standard of deliberate indifference. And it is a very difficult standard to overcome. When we talk about actual death penalty jurisprudence, we do look at the evolving standards of decency that mark the progress of a mature society. And we think that at least we only want to sentence people for the most heinous crimes, right? That's when we sentence people for death. We don't want disproportionate punishment. And some of these prisoners are saying, we're receiving disproportionate punishment. We should not be sentenced to death for the things that we came to prison for. What compounded the situation is that prison laborers actually became essential workers during the pandemic. They were producing PPE and hand sanitizer and all of the things that we needed to keep going. They were only being paid pennies on a dollar, like 31 cents to 71 cents, if they were being paid at all. And also, a lot of times they could not access the what they were producing, so they couldn't save themselves. They had no worker protection laws, and they were not high in vaccine prioritization, even though it was recommended that they be, in some states at least, didn't put them high. So modern day prison labor has actually become an extension of slavery, where there's exploitation of the laborer, and there's this need for labor, but devaluation of the laborer, his or herself. So I looked at a study that looked at the racial disparities in COVID deaths in prisons, and it was a collaborative study by the University of California, San Francisco, Brigham Women's Hospital, and the Harvard School of Public Health. And basically, it found that there was disproportionate death of non-white people from COVID-19 in prisons. And part of that is because they are represented disproportionately in prison, Black and brown people are, and because they have higher rates of underlying conditions. However, they found that even where white people had a higher rate of underlying conditions, still people of color actually died more of COVID in prison. Several things could be the cause of that. It could be that they lacked money for copays, or there were periods of time when copays were suspended. They may not have been aware. And then some communities of color, people of color, just have mistrust of the medical profession generally because of what they've experienced in the past with historical experimentation that has been just horrible, I think, especially in the Black community. So the risk of exposure was actually greater for people of color in prison, sometimes because of their work assignments and where they were placed. So in other words, they were placed in more densely populated areas, whereas white people were not. And what they are speculating is that even within the prison system, some of the same inequities that we see outside of prison are actually replicated within the prison system itself. So there's structural racism, there are environmental, economic, and social pathways that contribute to these problems. So in terms of official death sentencing, there's a case called McCleskey that basically said that you have to look at purposeful discrimination, have direct proof of discrimination to say that the death sentence is unconstitutional. And this was very problematic because it caused a lot of racial bias in death sentencing and also minimized the importance of empirical data. And what we have found also is that there is implicit bias from judges even who are predominantly white, predominantly male, and they tend to lack empathy, give more severe punishments, not be concerned as much about Blacks and other people of color receiving the death penalty. The good news is that this behavior is correctable once they find out they're aware. And also, we can use some more objective standards to help us avoid the culpability requirements. Going back to the Helling case, basically the objective part of it says that we should undertake scientific and statistical inquiry. We should consider the likelihood that such injury to health would be caused by exposure, and also determine the risk, determine whether the risk is one that society is not willing to tolerate. That's Helling, the objective component. This is actually a conservative approach. And I would say, in terms of addressing unofficial death, if we could eliminate the social tolerance prong, that is this last part of not tolerating it in society, with COVID especially, because there was so much division and not enough time for people to evolve, we really needed to move quickly. So we didn't need to do that type of analysis. And then eliminate the subjective intent or the culpability requirement. It would help us to minimize the deaths and get us to the place where we want to go. So the benefits of having such a modified approach would be we could rely on objective evidence as opposed to subjective evidence. We would not be considered to be activists, and I know that that's controversial. We can talk about that more later if you want to. It would reduce the impact of implicit bias and help serve the public interest while basically valuing all lives, including those of people of color and poor people. And that is a summary of my research. Thank you.
Thank you, Professor Dixon. Are there any questions?
Question about, so obviously COVID was a really stark example of a lot of these inequities, but do you think that with other smaller outbreaks of disease, of tuberculosis, of other communicable diseases, that there is still such a disparity, that there's still such a great indifference when looking at racial disparities, especially in that kind of context?
Yeah, and it really depends on what the disease is. I will tell you that with infectious diseases, there hasn't been a great deal of success in making the arguments. And this is why, I'm presenting this as one approach. I think that there are actually several, but I think part of the problem is the devaluation of the prisoner, really. I mean, this was a time when courts mostly went remote. So they saw the importance of protecting themselves. But you have people who are in congregate settings that have really the highest chance of contracting the disease when in close proximity like that. And very few courts actually saw the importance of getting these people out of that situation. Not only that, did not connect it to the fact that there were workers there who were getting sick as well because of the high spread, and these are essential workers, I mean the non-prison essential workers, and also what it was doing to the communities around them. So I think even like Professor Clark was saying, this sort of lack of empathy and how you see certain people or how you categorize certain people is problematic. But I would just challenge us to rethink it and maybe see it differently.
I just have a question too. Given the racist background that there is with forced prison laborers and how it affects more Black and Hispanic communities, why do you think it continues to be legal, to the fact that we still exploit them and then have no federal protections for them, like with OSHA or like any wage and labor, which obviously has contributed to a lot of deaths because of COVID, because there's no safety in place?
Well, and I'm going to go back to Professor Clark on this one too, because I think part of it is that we allow it. I think that there is a level of complicity in it. And I think if there were greater support, I mean, I know that there's support that comes from the scholarly community, but I just think in general, if people don't have someone who they know who has been impacted by the criminal justice system, it's difficult to get people to think about it. And a lot of people, face it, a lot of people benefit from it. They benefit from prison labor and laborers. So I think people tend to turn their heads the other way.
Yeah, I think it all goes back to Professor Clark's points, or lack of empathy sometimes. Mm-hmm. Well, if there is no further questions, there is also another chance at the end. Well, thank you, Professor Dixon. We really appreciate it. So we're going
Thank
to
you.
go now. Thank you. Then we're going to go now with Ms. Jaclyn Kurin. She's a staff attorney with the Abolitionist Law Center in Pittsburgh. She earned a master's in advocacy journalism from Georgetown University, a JD from George Mason Law School, and an LLM from UCLA Law School, where she specialized in criminal justice. Ms. Kurin has published several law journal articles on prison reform, bail, and police misconduct. While at UCLA, she worked at a civil rights law firm where she helped establish a new claim for suing the police, which has been recognized in federal court. Her work at the Abolitionist Law Center focuses on pursuing claims against the Allegheny County Jail for its unconstitutional treatment of incarcerated people. She also works on referenda to abolish solitary confinement and other harmful conditions in jails, which she'll be discussing today.
Thank you so much for that introduction and for having me here today.
Thank you.
So today I'm going to talk about using voter legislation to abolish harsh conditions in jails. And I'm going to start with the one in our backyard in Allegheny County, Pennsylvania. So in May 2021, Allegheny County banned the use of solitary confinement and certain weapons in the Allegheny County Jail, which we sometimes refer to as ACJ. That effort was born out of the experience of people who had been directly impacted by the jail, specifically those who had been currently and formerly incarcerated. And my hope is that you will consider using voter legislation in your communities to abolish conditions that are harmful in the jails in your backyards as well. So let's start. What is voter legislation? Why is it used? Talking about some of the benefits and challenges, and then specifically focusing on Allegheny County. How were we able to pass the referendum? And what are some challenges that we're currently facing in enforcing it? So to start with voter legislation, I'm using that term because sometimes in some jurisdictions it's referred to an initiative, other jurisdictions it's referred to a referendum. The key thing to remember is that the citizens are writing the proposed law. And to get it on the ballot, they usually have to get a certain number of signatures from the residents. And then the residents vote the legislation into place. So what are the reasons for why are we using this in the first place? Well, one of the key reasons to use this is there is administrative and political impasse. And by that, I mean that the people with power to make the changes are refusing to do so. So that's one of the reasons why we're using voter legislation. And another two key reasons is that it empowers impacted communities. The very people who are being effective have agency to change the policies at the jail. And then the other part is that it is part of an overall education effort to educate the public about harmful jail conditions. And specifically with these last two, those are so important because even if you have unsuccessful voter legislation, let's say maybe you didn't get enough signatures to put it on the ballot, or you got on the ballot, but not everyone voted for it. Not enough people voted on it to pass. It is still an achievement because in the process, you're educating the community about what's happening in the jail. You are humanizing the incarcerated people and their family. And that is an achievement in itself because this whole process is about legitimizing their experiences so other people know that they need to vote and make changes. One of the other really huge benefits, as we know in prison law, is with voter legislation, you can have immediate reforms to systemic problems. And we don't have to deal with the PRA, which is a very, very big deal to us. The other, in terms of challenges, one of the big ones is organizing. And by organizing, that includes both resources, in terms of having people to go out there and knock on all those thousands of doors and having the right approach to do so it's successful. And then it also costs money to do that. And then finally, of course, the enforcement of the voter legislation. All right, so let's talk about the Allegheny County Jail. And the most important thing to remember is the Allegheny County Jail, certainly at the time that we were considering putting this whole voters legislation effort in place, and just sadly still to this day, is the jail incarcerates people who are presumed constitutionally innocent, mainly people of color, and they have serious mental illness or psychiatric disabilities. And so how was the jail handling people with psychiatric disabilities? How did they respond? Well, they responded with force, and it was a lot of force. In fact, Allegheny County Jail, there are 67 jails in Pennsylvania. Allegheny County Jail per capita had the most uses of force out of all the jails. Year after year, there was more pepper spraying, there was more tasing, and there was more uses of the restraint chair. And this is what the restraint chair looks like. And I had a lot of my clients have been held in this. This is how the jail was responding to people who have mental health conditions. They put these people, strap them into a chair. They'd be there for maybe eight hours on end, no food, no water. They were left to urinate and defecate on themselves. And afterwards, they headed back to their cells where they were just to continue to be subjected to solitary confinement. And that's how the jail responds to people with psychiatric disabilities. So what did we do? Well, first, in the fall of 2020, our law firm, along with several others, filed a class action lawsuit to try to ameliorate the conditions. But lawsuits take time, and court orders are subject to the PLRA. And what could be done more immediately? So I'm going to talk briefly about the other administrative and political impasses we were facing that were preventing us from getting change in these manners, and so we had to consider something else. And the first one we'll talk about is Warden Orlando Harper. Obviously, he wasn't interested in changing his policies to treat people with psychiatric disabilities, ending solitary confinement, or excessive force. We were suing him. That was a non-starter from the jump. So what about the next person? Now, this is our county executive, Mr. Rich Fitzgerald. In Allegheny County, the county executive has a lot of power and has the power to appoint the warden. Mr. Fitzgerald has served as the county executive for over a decade, and as commentators have noted many times, if he wanted to change any of the policies at the jail, he could do so very easily by appointing another warden or telling the warden to do it. Instead, as commentators have mentioned, the county executive has kind of distanced himself from the jail while at the same time allowing unconstitutional conditions to persist, and even blocked efforts to ameliorate them, as I'll get into a little bit later. So our last political impasse was the Jail Oversight Board. The Jail Oversight Board is composed of about 9 members. Most serve ex officio. There are 3 that are appointed by community members, appointed by the county executive, and they actually have quite extensive power. They can they can investigate conditions at the jail, and they can pass motions to change the policies. And even though I'm noting that the Jail Oversight Board was an impasse, I do want to stress that there are some members on that board that are very committed to the people inside ACJ and the conditions they're subjected to. And one such person is Councilwoman Bethany Hallam. She has served on the county council for over 3.5 years. And while she has served on the Jail Oversight Board, she's done efforts to investigate jail deaths and improve conditions of confinement. She has provided stipends for people who are incarcerated so they can talk and communicate with their loved ones. She's worked to ensure that people have access to MOUD treatment, and at the moment she is attempting to pass a motion to ensure that people who are incarcerated workers are compensated. And part of the importance of also mentioning Councilwoman Hallam is she is influenced in part from her own experience. She was previously incarcerated at the Allegheny County Jail many years ago, but her discussion of the issues and focusing on the humanizing of incarcerated people has helped set the tone in this county to recognize people as individuals, as human beings, and their families as well. But as much as she's done, she's only one member, and there's still obfuscation in terms of reform efforts through the Jail Oversight Board. As critics have noted, going back to our county executive, he and his allies have attempted to obstruct or impede reform efforts through the Jail Oversight Board, whether it's sending unlawful designees to vote on things. Commentators have also noted that some members on the board might be resistant to certain reforms because out of a loyalty to the county executive who contributes to their campaign or points them to certain positions. So that is the landscape that we were facing. So now let's look at, okay, what does the referendum do? And importantly, how the heck did we get this to pass by 70% of the electorate? I mean, nearly 170,000 people voted to end solitary confinement at a jail. How does that happen? So this is what the referendum does. It bans the restraint chair, pepper spray, solitary confinement with a few exceptions, imposes reporting requirements, and those who feel that they are being held in solitary confinement unlawfully have a right to a habeas petition. So how do you get the public to vote for it? Well, one part is empowering the impacted community. And disgracefully, the African-American population is disproportionately represented in our jails. But by allowing using voter legislation gives agency to impacted communities to start making changes that affect those policies those in the jail and in effect their families as well. The other part to this was educating the public on jail conditions, and that was by centering the voices of people who were currently and formerly incarcerated. Now, critical to this effort were local journalists such as the Pittsburgh Institute of Nonprofit Journalism. Those journalists told the stories about all the experiences incarcerated people were facing, whether it be COVID, book bans, inadequate food, in addition to lack of mental health care, use of excessive force, and use of solitary confinement. Again, these stories humanized incarcerated people and legitimized their experiences. And also absolutely essential to this effort were organizations like the Alliance for Police Accountability. This is the organization that worked with others to collect all those signatures so this would appear on the ballot. If it wasn't for them, there would have been no referendum. And what they were also so effective at doing were relaying the stories of incarcerated persons, so people who even maybe didn't have family in the jail knew that this was a human rights violation that needed to be ended immediately. And that's how the referendum passed by a landslide. So the last part is enforcing the referendum. First, the good news. The good news is that the restraint chair hasn't been used since the passage of the referendum. That means the world to people who have been held in there, and they feel very proud for me to be able to say that, you know, how many people are placed in the placed in the restraint chair this year? 0. You know how many are going to be placed in the restraint chair next year? 0. And that's what it's always going to be. But we did have troubles. Immediately after the passage of the referendum, the county hired this man, Mr. Joseph Garcia, a militaristic contractor, to come in and teach our correction officers on how to interact with people with psychiatric disabilities. Even though the Department of Justice and multiple lawsuits and correction experts had testified saying his tactics are unconstitutional and are harmful. And our community was appalled to find this out, and we were worried about the well-being of those inside. So what did we do? We went back and organized again. The community came together, spoke out about how harmful Mr. Garcia would be, and we educated those who did have the power to make changes about how he would harm our people, our family members in jail. And the good news is the Jail Oversight Board canceled his contract. So the solitary confinement ban has not been a successful story yet. As you've heard, there's been a lot of lockdowns due to COVID. However, our jail has persisted in claiming and using facility-wide lockdowns for COVID when there are only a handful or nobody infected at the jail. Additionally, they have kept people with psychiatric disabilities in solitary confinement. But there is yet still some good news, because although there are enforcement problems, there are ways to resolve them. And one is by amending the referendum so to ensure accountability. Another is doing litigation through habeas petitions. And a new administration. We are voting for a new county executive, and incredibly, every candidate has promised to changing the leadership at the Allegheny County Jail. Of course, it will take a lot more, but that is a promising sign. And then finally, the last part of this is there have been other counties who have been inspired by what has happened in Allegheny County, who are similarly seeking to end solitary confinement at their jails. And as in Allentown, one of our largest cities here in Pennsylvania, they're trying to start a mobile health crisis response team, which would decrease interactions with correctional officers and prevent people from being incarcerated in the first place. Yeah. I'll turn off the sharing.
Right. Thank you, Professor Dixon. Are there any questions?
Yeah, I have a question. So during that, one of the most striking things was seeing the actual image of the restraint chair, and that was really heartbreaking to know that had been used on people just in general, in addition to those with, mental health difficulties. So I guess I'm just curious, is that kind of a par for the course sort of excuse me, is that sort of a par for the course sort of thing in, prisons throughout the country, or was that unusual? I know that you've mostly done your work with the Allegheny County Jail, so I'm just curious about how deep this problem goes.
It is used in other correctional facilities. We do work with the Pennsylvania Department of Corrections, so it's used in prisons as well. And just part of the use of force numbers that we get from is looking at other jails, that those 67 jails, a number of those jails use it as well. At Allegheny County, these are just the reported numbers. So the actual numbers are most likely much higher, is just used on a daily basis and just reflexively in response to anything that they deem non-compliant, even if it's a manifestation of someone's symptoms of their psychiatric disability. That was the response.
Okay, thank you.
I have a question. So are those that work within the prisons, are they trained for dealing with psychological disabilities? Because then it just seems like they're using the lockdown as a pretext for them just to put them in solitary confinement. How does their training work when dealing with people that have issues?
So part of the class action lawsuit, a lot of it has to deal with an inadequate training and making sure that, the correction officers are getting training in de-escalation, verbal de-escalation and crisis intervention. There's a long list of training programs that they need, and actual experiential programs, not just like looking at your phone and just reading over, this is what's supposed to be done.
Excuse me, I have a question. Before the referenda, what was the reason for the restraint chair? Is it because they only had psychological disabilities, or was there something else to it?
I guess it depends on who you're asking. A corrections official will say non-compliance, but like, I want you to go into your room. It could be something as simple as that. And rather than talking it out with the individual and saying, okay, is there a reason why you don't want to go in your room? Oh, your room is really dirty and you're pregnant, and that would, endanger your health and your child's health. So let's find you a different cell. I'm giving this example as one of my cases. The response is to immediately, let's use pepper spray, or with someone else, they want to file a grievance. Let's just put you in a restraint chair. It's a response to any activity, constitutional activity, nonviolent activity, innocuous behavior. And so we had to stop them from being able to use those weapons. And the referendum is just, a part of that. Again, it's, I guess part of the thing to take away with is the movement lawyering aspect behind this is the centering of those who are actually impacted, having them tell their stories on their term, their experience. And because jails and all carceral institutions are a black box, there's no transparency of what's going on. The public doesn't know what's going on. And we need to hear those stories to know what exactly is happening within those walls.
Yeah. Thank you for informing us about that. I think it's something we need to know more about, how we can, change the logistics of jails and how they deal with it through our own voting referendum. If there's no further questions, there will be time at the end, but I will go with our next guest, Miss Megan McGowan. She is a librarian in Detroit and a member of Library Freedom Project. Prior to working in librarianship, she worked to connect incarcerated people living with HIV to resources throughout their incarceration and upon their release. Also, I want to welcome Professor Nicholas Norton. Nicholas Norton is the Research, Resource, and Inclusivity Initiatives Librarian at Cornell Law Library. Prior to joining Cornell, he received his MLIS, JD, and BA in Asian Studies from Wayne State University in Detroit, Michigan. So thank you for being here.
Yes, and can you hear me okay? Okay. Thank you all for having us, and for the really inspiring and horrific papers that have been discussed thus far. And similar to Professor Dixon and Ms. Kurin's papers, our paper outlines a specific problem in the prison industrial complex caused by this, rampant dehumanization that Professor Clark kind of introduced us to at the beginning of this, the dehumanization of incarcerated people generally, systemic racism. And so our paper didn't actually start as just a scholarly project for myself and Megan McGowan. We actually didn't know each other, even though she works at Wayne State, where I went to school. But we were both on this listserv for the Abolitionist Librarian Association, because we're both librarians. Like, I went to law school, but I'm a law librarian. So for those of you in law school or legal professionals, like, I'm the type of person who helps you do research and teaches legal research. Megan is a librarian who isn't law focused, but has worked in the prison industrial complex type of advocacy space. And so we were both on this listserv. And in the summer of 2022, there was this lone NPR news story. There wasn't really any other reporting on it that happened at the time. And it was about this ban of non-English dictionaries in Michigan Department of Corrections facilities. And so I I first heard about it on this listserv that we are both on, and was just really disgusted and troubled by reading this article that, similar to what Ms. Kurin was outlining about local journalists and them bringing a voice to, incarcerated people on the ground. There was all these interviews with individuals who were trying to access like a Spanish to English dictionary or a Swahili to English dictionary in the prison. And the reason for the ban from the Department of Corrections was that they felt that having these dictionaries in different languages would somehow threaten order within the carceral institution, because it would allow inmates, or incarcerated people rather, to learn different languages and communicate with each other in languages that the Department of Corrections staff wouldn't be able to understand. And you can think of many different ways in which that type of logic doesn't really make a lot of sense, because, what if you go into prison as somebody who speaks a different language already? Like, you are like, a lot of the stories and testimonials and articles and literature on this speak to how somebody who's an incarcerated person trying to use a Spanish to English dictionary, for example, is most likely trying to learn English, not trying to talk in code. And then also just the dehumanization of not being able to read in your first language. And so there was just so many different problems with this dictionary ban that a number of us on this listserv decided that we wanted to do something about it. And we were, I'm originally from Metro Detroit. And so Megan, myself, and a few others started to converse in email, and then decided to have kind of like a bi-weekly Zoom call. And we were trying to figure out, like, how can we do some kind of advocacy around this issue? And our main thought process was to first see if there was any existing advocacy that was already happening. We didn't really want to presumptuously kind of step into this space if there was already some type of advocacy organization that we could just support and bolster their efforts. But when we kind of did a survey of that, we didn't find any organizations that were doing any active campaigning on this. We found one that had done kind of like a telephone 1 week kind of advocacy blast on the topic, but then after that, they didn't continue any other type of work on this specific issue. They work on prison industrial complex advocacy generally. So when we found that, we decided to write an open letter, and I think Megan just put it in the chat. And part of the reasoning behind having this open letter was that it would be a way to have people sign on and raise their dissatisfaction with this ban. And it could be something that brings in, librarians, information professionals, lawyers, non-legal and non-library folks who are just committed to people having access to reading and freedom to read in prison. And so we got a number of different signatories. And in the research process for the construction of the letter, it was very interesting because I had dug into the Michigan Department of Corrections regulations, and a number of them spoke to specifically how the library is supposed to have a well maintained reference collection that has materials in multiple languages to serve the patrons. And so their own policy directives were conflicting with one another. And in addition to, we found a bunch of examples from other states where not banning dictionaries per se, but if somebody was trying to ban in like New Jersey, for instance, Michelle Alexander's A New Jim Crow, and then the ACLU wrote an open letter on that and was able to get the Department of Corrections there to throw out the ban rather than go through litigation on the First Amendment question. So we felt we were pretty good on you have a First Amendment problem here, Department of Corrections, and you have this other regulation that you're violating. So our thought process was that we were going to get all these signatories, alert the Michigan Department of Corrections folks of the letter, and then if it didn't go anywhere, we were going to try to hand it over to a public interest law firm. And we had like some preliminary conversations with Detroit area, like ACLU and other public interest oriented folks who were interested in working on this. But then we found out like a couple weeks after we got the open letter circulating that they reversed the ban and were allowing the dictionaries again. And so we decided later to document this advocacy effort, and that's where the paper comes in. So I'll turn it over to Megan to describe the paper.
Yeah, so thank you for having us. Can everybody hear me okay? Cool. As Nick said, we were motivated to write it because in our background research while drafting the petition, we found that it was hard to find comprehensive texts about availability of information to people incarcerated in Michigan specifically. So our goal was just to expand knowledge around censorship in Michigan prisons. So we split the paper into two main parts. Because Nick is a lawyer, Nick wrote the portion on access to courts and legal reference, and I focused more on general reference, including access to nonfiction materials like career building information or history texts, dictionaries. And our argument for the paper is that although MDOC rescinded the non-English dictionary ban, nearly 33,000 people incarcerated in Michigan's prisons still have serious information and access to court gaps that are completely unacceptable. And our article argues that people who are incarcerated deserve libraries that meet both the right to read and the right to access courts. So in the broadest terms, what we found was that people who are incarcerated have very limited and inconsistent access to information. So that's even though in Michigan, each prison has their own library with at least one librarian, but there are still barriers to access throughout the system. So in addition to censorship and limited budgets, often allotted libraries, there are issues like where is the library located within the facility? Can someone get there in their time allowed to access the library, or do they have like a conflicting obligation like labor obligation or medical requirements? Are they able to read? If they are able to read, are there materials that are at their reading level? Do they read primarily in another language? Because even though they reversed the dictionary ban, Michigan prisons still have a policy against collecting non-English non-English materials. So novels in Spanish, anything not in English, they don't collect. So in that way, they're not able to meaningfully access the library. Do the materials they're looking for exist in the collection? For example, if they're looking for like self-help books, do they even collect those? And then are they afraid to access what they need to access because of surveillance in prisons? Are they afraid of being persecuted by staff or others who are incarcerated because of there's no privacy? So that is also a barrier to access. And then another issue we covered in our paper was the increased use of offline database access, which people use to primarily look up citations. So they do that on a computer. So as people have had increased access to these like digitized indexes, the time allowed in the library was limited because wardens have assumed that people have technological literacy to navigate computers and can therefore find that research faster. Anyone who has worked with people in public institutions or like even some of your relatives probably know that that's a false assumption. We do not all have technological literacy, especially for people who have been incarcerated. Even for a decade or more. Think of all of the things that have shifted in the last decade, right? So whether that was an unintentional oversight or an intentional limitation under false pretenses, I'm sure most of us in this group can guess, but we don't know that. So then we concluded our paper with some suggestions for improvement. This section felt particularly challenging because we are abolitionists and know that people should not be incarcerated, and our current system is inhumane. But people are presently incarcerated and need access to resources now. So what are some things that could happen to maybe bolster that process? We offered that funding should be pulled from MDOC to manage libraries and instead be managed by the Library of Michigan. So most people who are incarcerated in Michigan, if they need legal reference help, they write out to the Library of Michigan. So they're already working with people who are incarcerated. It would be a natural transition. And we suggested that this was an abolitionist solution because funding would then be removed from MDOC to instead be managed by librarians rather than wardens. And we would hope that this would limit opportunities for library services to be limited punitively, or for MDOC to continue to arbitrarily censor materials, and for the budget, the possibility of the budget to continually be siphoned from library services, right, and put into more security-focused measures or whatever that warden has decided they might need. That's not the library. We also asserted that there should be more oversight for censorship from people outside of the Michigan Department of Corrections and sympathetic politicians to MDOC. So like maybe public library workers or educators or people who have been or are incarcerated, right? On like a type of censorship oversight board. And it's worth noting here that in some states like Ohio, banned books are reviewed every 4 years. In Michigan, it does not appear that there is any revisiting of the list unless they've been book-specific things have been challenged by the public, like non-English dictionaries. There was also a Fanon book that was challenged and they reversed. But on the current banned book list, we found materials like Dungeons and Dragons books, money management books, Black history books, IT career books, truck driving training materials, like a CDL materials book. And then the list extends like decades prior, probably to like when the list was digitized. Like we're talking late 90s. Like, so I'm sure there are books on the list that extend back as well. They just didn't make it online yet. So in that vein, we also argued that there should be more substantial reference collections, like Nick had mentioned. And then we encouraged the use of partnerships with public libraries and academic libraries and reference by mail organizations. My concern here was that by like arguing that MDOC should partner with outside organizations, that public institutions are then legitimizing the prison industrial complex. But the more people who have eyes on and in prisons and the more resources that are available to people who are incarcerated is always a win. And this didn't make it into the paper yet, but I'm going to add it when I do my edits. But there are organizations that function completely separately in order to avoid this exact contradiction, right? Like the Prison Library Support Network, which is a volunteer-based organization made out of library workers mostly, but I think they allow anyone that responds by mail to people who are incarcerated and ask reference questions. So an example of like the kinds of information that people are looking for, like all of the things that you expect, like legal questions and medical questions and kind of like the big questions. But we also get questions like, how much is a used pontoon boat? Like, so if we think about the ways that we like use our phone throughout the day to like pick up and Google, like, who is that actor again? Like all of these things that just don't exist when people are incarcerated. And then finally, we argued that there should be more support for jailhouse lawyers and Michigan needs to strengthen the right to access the courts, which I think Nick might touch on after I'm done talking. And then there are two main barriers while doing this research. So it's difficult to find information in closed systems. I think someone had previously called it a black box. We found that to be true as well. And also policies vary widely from prison to prison. So even though there are these overarching policy guidelines within state prisons and also within federal prisons, it really depends on who is staffing the mailroom, who is a librarian at the prison, who is the warden at the prison. So all of these like really, this intricate system of power can really disrupt access to information. So as Nick said, this paper is not the end of our work on information advocacy. And when the paper is published, we hope to restart advocacy around information access, kind of using the article as a starting point for increased conversation. We've mapped out some possible plans to kick this back off, and we hope to partner with others doing similar work. I did want to mention this because I know not everyone is from Michigan. Ithaca SNR just released a really comprehensive report kind of comparing state prison policies, what people have access to in prison. So I'm going to drop that link. But for now, I'm going to kick it back over to Nick.
Yeah, and just to quickly wrap up our section, like as Megan outlined, the two functions of like a prison library, when you think about it and kind of read about what they do, like there's the law library side that like tries to effectuate access to courts and a prisoner like filling out pro se or appellate documents if they have representation as well. And then there's the prisoner's general right to read stuff. So, like if they're trying to read just general like pleasure reading material, or just look at a dictionary. And so the article kind of outlines the evolving legal standard over time of both of those sets of cases, because they are slightly different. And so the access to courts and prison law library side, you'll see that over time that right has gotten really watered down, and there needs to be a lot of work done and advocacy to strengthen that right. Because going from when the right to access courts was first articulated in the 70s to this Lewis v. Casey case in the 90s, there's a really pernicious standing analysis where it's very difficult for somebody to allege as an incarcerated person that the really inadequate law library, that they can say that they were actually injured or were going to actually succeed on the merits, even if that law library was great. So that's a really terrible problem. And then there's a separate issue of all these censorship problems. And so it's very difficult for an incarcerated person to try and strike down these prison regulations, because the prison can often just say like, oh, it's for safety and order. That's a really broad characterization of a lot of these things. So there's so much court giving discretion to Department of Corrections facilities, and not challenging a lot of these assumptions. So that's where we'll end, and open it up to any questions from you folks.
I just wanted to comment that I think that it's just such a wonderful idea to have either like outside organizations and universities, or to have individual volunteers and different networks like working with people who are incarcerated, and knowing that, like, not to tie everything back to Professor Clark's piece, but knowing that it is so crazy to think that you can't just Google every thought that comes in your head. And so someone who's incarcerated does not have access to even basic information. And if you've been incarcerated for a long time, you don't have access to the news and what's going on every day. And I think it really is just such a wild concept. And for all of us to sit here and think about that, I think it's lost. And we understand, I think a lot of us, that a lot of people who are incarcerated don't have access to the legal resources they need. And while people are trying to file writs or to challenge their incarceration, how difficult that work is, because it's intentionally difficult, because it's legal work. So there's that side of it, but then also just having someone there to help you look up things that you're interested in, like pontoon boats. So I think it really is just such like a wonderful thing to see that there are organizations that are working to help people, not just with their legal concerns, but also with just their everyday life concerns while they're incarcerated. So I thought that was such a wonderful suggestion in your piece.
And I also have just like a comment / question. So the reason for why we have prisons is for rehabilitation, allegedly, to help them go into jail and, become better people. So by not, giving them access to information, by censoring information, I think it does, but wouldn't that kind of go against the whole purpose of why we're putting them in jail, why we're expecting them to learn? However, we're not giving them the resources to learn and grow.
Yeah. So learning and growing, thinking about mental health materials, or people being anxious about returning to society, but they can't check out a truck driver book. It also thinking about news. So often there are newspapers in prisons, but if you're incarcerated in rural Michigan and you actually are from maybe somewhere on the Indiana border, I don't know, maybe your community newspaper is not there. So it's also further disrupting communities, right, when you're pulled away. I mean, all of the ways that information, it seems frivolous, right, to argue that people should have access to novels. But the way that prison intentionally limits people's imagination by banning things like Dungeons and Dragons, by banning novels, it forces people to be present in this really inhumane, insufferable conditions, right? And you just give people no escape to maintain any sense of self, to improve themselves at all if they want to. But even if people just want to read because they would like something to do, it's horrific. But yeah, thinking about, now I'm on a tangent, but thinking about rehabilitation, certainly no. right.
Yeah, that's what it seems like if they can't even have access to basic books on learning how to maybe acquire a job after their release, or like I know there you mentioned coding or truck driving guides, just basic stuff that they don't have access to, then how do we expect them to be better after release? So it's definitely an interesting point that you bring up in your article. Are there any other questions? Okay, so yeah, same thing at the end. We'll have more time for questions. So thank you. So now we'll go to Professor Sarah Ryan. She's an associate professor of information science and director of the law librarianship program at the University of North Texas. In 2018 to 2019, she clerked for the Honorable Victor A. Bolden in the District of Connecticut, where she worked on criminal resentencings under the First Step Act. Since her clerkship, she has written on judicial authority and administrative responses to the First Step Act. Welcome, Professor Sarah Ryan.
Thank you. It's so great to be here. And, this is a difficult topic tonight and an important topic, but this session has left me really hopeful, just hearing about all of the advocacy work that's going on. So I am going to talk about the First Step Act. And at the end, because I am a proud law librarian too, I'm going to do a little research demonstration, but I just have to say that at the beginning that, this session has left me so hopeful. So I am going to situate my remarks in the 2018 First Step Act. At the federal level, this was hailed as a once-in-a-generation criminal justice reform. So, yay, we lived through it. We've seen the biggest criminal justice reform, and yet, the other side of tonight is that there's so much work left to be done. Second Circuit Judge Guido Calabresi deemed the First Step Act simultaneously monumental and incremental, and I think we all probably feel that about a lot of initiatives. The First Step Act that I'll talk about was monumental because it freed thousands of people. It allowed inmates to file for their own compassionate release. Compassionate release was a corollary to some of what Professor Dixon was talking about. It clarified good behavior credits, and yet it was really incremental because many long-serving defendants who had sold too little crack, for instance, stayed incarcerated, and it barely scratched the surface of many needed prison reforms. I want to talk for just a couple minutes about my own experience with the First Step Act, because I know that there are so many law students on this call. And then I'll talk a little bit about my paper, and then I'll do a quick research tutorial. We'll see how much time I'm timing myself, so I'll stay within bounds. I just wanted to say that working on some of the First Step Act cases as a clerk was just life-changing. Those of you who are debating whether a clerkship is worth it, whether you should, put your hat in the ring for a federal clerkship or 30 and see if one makes it, I would say definitely do it. It was incredible to be working on a brand new suite of legislation. It challenged everything I thought about research and advocacy, because when you're clerking, usually the first thing you do is you go find what your circuit has said about a particular statute or a particular issue. And in the case of a brand new law like the First Step Act, it's a first impression before your court, and the Second Circuit hasn't spoken. And you and your judge have to figure out how the Second Circuit might speak or should speak, and it's just incredible. It was also incredible to be part of what I've written about since then. So I've done 2 papers on the First Step Act. This is my second. The first one was about resentencings. One of the things that the First Step Act did was allow judges to reopen, to resentence old cases. And they had to figure out what that meant. And there wasn't a standard for what this type of resentencing looked like. Did you go back to the original pre-sentencing report? Did you ask probation to prepare a new pre-sentencing report? How did you weigh what the person had done while incarcerated versus what was even available to them? As my paper describes, many prisons fail to provide even half of the credits and programs they claim that they will provide or that inmates are entitled to. But judges had to grapple with this. And in working with my judge and then in researching hundreds of these cases, again, like tonight, I became really hopeful because I found judges across the United States taking risks and saying we do have the authority to look at the full record We know Congress only authorized us with 4 sentences of text, but we know what our role is as judges, and we're going to open these cases and really look at these human beings. The second thing happened in some cases that I write about in this paper. In this paper, I write about a couple of things, one of which is compassionate release. And compassionate release was one tool, along with the CARES Act, along with the Attorney General memo that Professor Dixon talked about. And most compassionate release cases were not successful. Courts denied 80%, federal courts denied 80% of compassionate release requests, mostly brought by inmates. But they granted 20%, releasing about 2% of the federal prison population. And if you look at those cases, in both instances, on both sides of that equation, you have judges going out on limbs. In some of the cases that I don't love, judges were making up epidemiological standards. Like an individual person had to prove that a vaccine that was brand new couldn't work on them, given their genetics. I don't know. That wasn't very clear. But then in other cases, judges accepting news reports of prison conditions and testimony, and really trying to look at a full picture of outbreaks that were just beginning to happen and releasing people. And my paper goes into detail on both sides of the equation, but again, there is reason to hope there. There's also reason to get really frustrated with Congress about not providing enough guidance in the First Step Act and in many criminal justice initiatives to tell courts what they're allowed to do, or what evidence they should be looking at, or if this is supposed to be a monumental criminal justice reform, what that would look like procedurally. Again, I want to stay on time because I want to show you a couple of research things, but my paper delves into some of those case studies. And case studies, to me, are really one of the ways that we all can contribute. Some of you are going to be attorney activists like Attorney Kurin. Some of you are going to be law professors like Professors Dixon and Clark. Some of you will join the bold ranks of librarianship. But there is a place for good researchers in all of this. And I point out a couple of cases in my paper. One is the case of Sean McQuitty. Sean McQuitty died of COVID in prison. And his public defender had to inform the court of his passing. I mean, imagine that. You're a public defender and you have to tell the court that didn't free your client that your client has died. The court documents describe, when they instituted hospice and called his family. It's heartbreaking. And the case was featured by The Guardian. It was featured by some well-known criminal justice reform think tanks. But when I started digging into the McQuitty case, I found more going on. And that's where I want to take us now. I want to do that research presentation that I promised for just a couple of minutes and encourage you all to do the same. One of the things that I think is missing from much good advocacy is just dogged journalistic legal research. And that was important for me in Mr. McQuitty's case. The Guardian said this is a miscarriage of justice and it's pretty straightforward. It's this Trump-appointed judge. And several think tanks used the McQuitty case as well and said, it's really this Trump-appointed judge is the reason that this man died in prison. But when I started digging into PACER, and I hope you all love living in PACER. I love living in PACER. You all can set up your own PACER account. Yes, you associate a credit card, but your first 300 pages are free. It is so worth it to live in PACER, especially for this kind of work. So when I started digging into the McQuitty docket, what I got was a much more complex argument about what was going on in the McQuitty case. And when you dig into dockets like this, you dig into decades of history of this human being and everyone that interacted with them. And one of the things that I found as I dug through this docket was that Mr. McQuitty's case kept getting kicked between different judges. Okay, of course, magistrates and district judges, but just as Mr. McQuitty was coming up, and I should have written down the docket number. Okay, trust me, right around the time that we're getting to the First Step Act, the judge who's most familiar with Mr. McQuitty's case, the second judge on Mr. McQuitty's case, punts it to a new judge who's just gotten onto the bench as the First Step Act is unfolding. And then shortly after that, we find ourselves in a pandemic. And so, you know, the Guardian story is true and the think tanks are true that Mr. McQuitty is a travesty, but it's not just a travesty of a Trump-appointed judge. It's a travesty of an underfunded court system. It's a travesty of a court system where there isn't enough coverage, that judges have to kick cases around to each other, even when major criminal justice reforms are happening or when a pandemic is happening, right? There's something bigger here than one judge and one person that we've lost. And so that's the first lesson. All right, I didn't even ask. Could you all see Pacer? You all see me in Pacer? You all live in Pacer with me for a second. You know, Abigail and Professor Clark had a nice conversation earlier, and we've kind of riffed on it since then about, like, you know, is this information cloaked? And, you know, I defer to my librarian colleagues that yes, much of the information that they needed, like what's actually in the library, is not available. But I'll echo Professor Clark that a lot of information is available. So I use this from the Bureau of Prisons in my paper as well. And what it shows is that the first BOP director is in 1930, right? But as we go along, there in 1964 is the third BOP director, the fifth BOP director in 1987. And since 1992, we get BOP director number 6, number 7, number 8, number 9, number 10, and number 11. This is a dysfunctional organization that has a leadership problem, and they're not hiding it. It's on their timeline, right? And so as researchers, we can bring that up. All right, other things that I used, the Department of Justice. One of the sources that I used in my paper to talk about how decrepit the prisons were and why judges should have let people out on their compassionate release claims came from the federal prisons, from BOP's own budget request, right? And so that information is there. BOP is saying our prisons are decrepit and old and they shouldn't be housing people. And then they turn around and say something different. And finally, I used oversight.gov to look at Office of Inspector General reports. I need to stop because I'm a professor and an attorney and a law librarian. I do a research demonstration all night, but I hope the point is very clear that there is a lot of information out there. The public, advocates, city council people, whomever, need us to pull this information out of these systems and put it together in a way that many journalists are failing to do, even with good intentions. So thank you.
Thank you. Are there any questions for Professor Ryan? I have a quick question. After the death of Mr. McCuddy, I think, has there been any type of changes to the compassionate release, or has it still had the same challenges that's been facing for years?
The First Step Act changed something huge about compassionate release. It allowed defendants to file the motions themselves. Prior to the First Step Act, the Bureau of Prisons brought these compassionate release claims, and a couple dozen a year. And I'm talking all federally now. I have not studied various state compassionate release procedures. One of the interesting things that happened under the First Step Act when inmates were allowed to file for their own compassionate release is that judges realized they didn't really have a standard for that, for inmate motions. And they had to grapple with the fact that inmates often didn't have access to information, even information about, for instance, administrative exhaustion and how they were supposed to file their paperwork within the prison. And so I would say there's a lot that courts are still grappling with in this area that has all sorts of names, right? Compassionate release overlaps sometimes with habeas, overlaps sometimes with some other means of releasing people who are vulnerable and are in places that can't meet their needs. And so there is still a great deal of uncertainty.
Then if you have this information, I don't know, but how successful are these inmates? Because I know, like, Professor Norton and Ms. McGowan, they bring up a point how a lot of inmates don't have access to legal books or legal information. So having inmates petition it themselves, how successful is that if they don't have much accessibility to certain things that could help them with their case?
Sure. So there's some stark statistics in my paper about, and this comes from some pretty careful record keeping by the federal courts in 2018, 19, and 20. And what those statistics showed was that there was this widespread geographical disparity. So in certain districts, their rates were as high as 40% of these motions were granted. And in other districts, they were lower than 10%. And so, but that was a particularly robust data collection effort, and again, by the federal courts. But what it did show was just wide disparities. I think it was Professor Dixon that said, luck of the draw. You know, are you incarcerated in Alabama? Are you incarcerated in the District of Connecticut? Who's your judge? You know, there's still, there are some statistics that bear out that luck of the draw argument.
Thank you. Are there any other questions from anyone? Okay, well, if there isn't, we still have time to ask, but I would like to call Mr. Parrish Collins. So during Professor Dixon's presentation, we received a message, and he works on prison medical abuse cases, and he would like to offer some insight and some thoughts. So you can just unmute yourself and share some information with us.
I'll try to get it brief. Thank you all for your discussions. It's like Professor Ryan, I'm pretty optimistic seeing all the young people. I got into the prison stuff pretty late. When Jeff Sessions got appointed, I thought I'd do my civic duty, take a couple of cases. Since early 2018, we filed 60 of these. We could have filed 200. It's, in my estimation, it's the most dangerous part of prison is the medical care and the food. And there's so much ground to cover, but someone had mentioned or asked earlier how to get involved, and the prisons are kind of a black box, but not really. The Inspection of Public Records Act, acts around the country are pretty powerful. We probably sent out close to 2,000, and we probably know more about the New Mexico Department of Corrections than they know about themselves. We also know more about the medical contractors, and we've run. Well, I like to think that one of them left the state because we sued them so many times. It's a billion-dollar corporation, and I intend to follow them around the country. The one thing that I would suggest for any of you young folks who want to do research, just start submitting Inspection of Public Record Act requests. I would start with contracts with everyone, the food vendors, the medical contractors, the security contractors, because they have to provide it. And then all the contracts that those people have with the secondary contractors. But you can get all this information, and you can get the request for proposals. You can get their responses to the request for proposals, and it's pretty shocking. their performance compared to what they promised to perform. And I looked up the Michigan, since someone was talking about Michigan, and the contract right now is with WellPath. It's with Grandparent Prairie Health Services, which is part of WellPath, meaning Grand Prairie Health Services is a shell, because WellPath is close to $1 billion corporation. And I get the contracts with WellPath, work your way up the ladder, organizational charts and things of that nature. And then, I would encourage anyone that can to file a lawsuit against these people. But in the meantime, the other thing you should start looking at, which will tell you a lot, is the American Correctional Association does audits on jails and prisons. Obtain all the audits, because you will find all kinds of falsehoods. Elizabeth Warren did a study on the ACA. It's a total sham. Like we've had, I don't know how many of our clients have died, and the medical providers get 100% at every single facility, every single year. And then their stats are completely inaccurate. So I would do that. And then things that you can do for the inmates, you can send out notices of claims. I don't know if that requires a legal background or a law license, but under most tort claims acts, and we start these in state court because of discovery. If you go to federal court first, you're probably going to get kicked out on the first day. So we start in state court, and there are tort claims act requirements. You have to give notice, and so sending those out, we've sent out probably close to 1,000 of those. Even though we can't help everyone, we can't take all of them in for litigation, but they have to be filed, or the inmates can't file suit later. And the same goes with filing grievances because of the Prison Litigation Reform Act and state counterparts. If you don't go through the grievance process, then you don't get into court later. And the other thing is you really need to document it, because we've caught the Department of Corrections here lying on every single case. They say our client didn't file tort claims notice or a notice of claims and a grievance. And then we get them because we get them from our clients before we start the suit. And then, I mean, those are things that you could do that would make a real difference to inmates. And as far as the approach we're taking, and I was listening to Professor Clark, the demographic, we've done a fair amount of study on this. There's a huge rate of learning disability. I think it's over 80%, over 50% dyslexia. There's 80% have mental health issues. And the schools, because of the schools, these people aren't getting help, and they have almost 1 foot in prison the day they're born, and people don't care about these people. So what I'm looking at, and it's getting a lot of interest from some national press, and hopefully they start printing some of these articles, is I'm pretty sure this is so in every case or every state and every county. The way the contracts are written, and it's actually Medicaid, it's called short-term Medicaid for incarcerated individuals. So if an inmate, if one of these contractors sends an inmate out for diagnostics or treatment, we got a lot of infection cases that were easily treated that turn into sepsis, osteomyelitis in the spine, endocarditis, heart disease, brain infections, and but they're easily treated, but they don't send them out for antibiotic therapy. They don't even do the testing to determine if they have the infection. By the time they send them to the hospital, they're leaving sometimes either dead or in comas, and they're in the hospital for a really long time. But if the contractor had sent them out, for the proper care, diagnostics, and treatment, they would have to pay everything. If they wait until that inmate is hospitalized for 24 hours or more, Medicaid picks up 100% of the bill. And that's what I'm pushing. It's because, people don't care about prisoners and drug addicts and, the demographic we're talking about, but they do care about taxes. And this is, there's a lot of researchers on here, but, I would encourage some enterprising researcher to figure out what this is costing the country, because it's probably hundreds of billions. And the reason being is because the when they're in prison, they're pushing all the medical costs back to Medicaid, back to taxpayers. But in addition to that, a lot of our clients have permanent, severe spine, heart, brain damages, amputations, from not treating diabetes and so forth. They can never work again because they worked in manual labor. And even if they had been an investment banker, they probably are going to be working in manual labor after prison. You can't do that with a damaged spine or a damaged heart, and it doesn't get better with age. And most of these guys are pretty young. So you're looking at lifetime disability, lifetime Medicaid. And no one's studied that issue. Like, what's this actually costing? And I think if someone, could figure that out, and I'm trying to figure it out in New Mexico, they're pretty invasive, but I'm getting pretty close to, I know they don't pay for it, but, we're, they're not, we send out requests for admissions, just admit you didn't pay anything for this hospitalization, and they hem and haw. So now we're having a 36 deposition with one of the contractors to basically nail them down on that. But that is the case, and I plan to prove it in New Mexico. And, I would encourage, all of you young folks to, look into this issue, because I started out thinking, wow, if people knew what was going on, they would be shocked. It's just so cruel and inhumane. How can anyone not be shocked? But the recovery response is just like, that doesn't affect me, but taxes do. So anyway, I could literally go on for days on this, so I'll just stop talking. But, thank you all. It's really cool to see all the young people out there, that are interested in this, because it's a massive, massive problem. And until you talk to 1,000 and, prisoners and their families, or more actually, you have no idea the medical horrors that are occurring right now as we speak, probably in every jail and prison in the country.
Yeah. Thank you. That's very insightful. I think it's something we were aware of, especially in New Mexico. But so thank you very much for that. Being that there's no questions, we'd like to thank Professor Clark, Professor Dixon, Ms. Kurin, Ms. McGowan, Professor Norton, and Professor Ryan for their time. They provided great information, great resources. We really appreciate the research you've done and your continued mission to change the current state of prisons and jails. I think we've learned a lot, some things I didn't know about before, and I now know. And I really appreciate your time tonight. Abby?
Yeah, I just would echo everything. We are so, so grateful that you all are doing this great work that is so important and going to make a change and going to do great things, not only for people who are incarcerated and their families, but for all of us who live here and across the globe. So we are just so thankful for all the work you do, that you've chosen to publish with us. And we so look forward to publishing this wonderful issue in the coming month. But thank you so much for everyone who has come, everyone who has given into this cause, and we are just so grateful for everything, and we are so appreciative for all of you. And like you said earlier, I leave today feeling very hopeful in what can oftentimes be a very scary field to be a part of, a very sad field to be a part of. I feel very hopeful after tonight, and knowing that there are so many people who are doing great work, who care about these issues that are so important, and are all hopefully going to make a wonderful change. So thank you so much, everyone. Have a wonderful night, and definitely read the issue when it comes out next month. Have a good night.